and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Please raise your hand. Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can be seated, all right? Before I start asking you questions today, have you consumed, substantive questions, let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line from Moscow that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence showed that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the 3rd floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor, it was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walenta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman, And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Logan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted. And that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Maddie Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first-degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first-degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely, and certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than 1 full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in 1 day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right,
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it, it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
Another moment here before we do bring in Joanna Nieves, who is an attorney. So we will be sharing those here with you in just a matter of moments. I do want to begin that discussion, though. So let's bring in Joanna Nieves right now. Thank you for joining us. And Joanna, as we just watch that unfold, I think the word that comes to mind for me is this was very dense. So could you break this down for our viewers? What we did just listen into there as the judge read aloud those counts and what Bryan Kohberger just agreed to as he did plead guilty.
Yeah, absolutely, Christy. So the judge has to make a finding that this was a knowing and voluntary plea. So what he's doing is reading the charges and making sure that the defendant understands what he is pleading guilty to so that he can accept this guilty plea. So what you heard was him recite all of the charges against him. The prosecution then stated the factual basis for the plea. There has to be a legal basis for this finding of guilt, and the judge accepted the statements that were made by the prosecution as the factual basis. And then he turns to the defendant and says, how do you plead? Guilty on each one of these counts, and then accepted the plea. So now we're in a place where the judge can sentence him based on the fact that this guilty plea has been entered.
Well, let's talk about the sentencing here. So in terms of, we did hear the judge say, is a day long enough? So when do you think we're going to be getting the sentencing? Is this going to be pretty quickly here, given the fact that he did his plea deal?
I do think that the judge will get to it relatively quickly. He was indicating that he had some time set aside. What the both sides are going to do is submit their statements of aggravation and mitigation in support of the sentencing. We are going to hear from some of the victims' families and their impact statements. I think the reason he was asking about the length of time and whether or not that was sufficient is because there are a lot of people who were impacted by these murders and these losses, and he is going to give them the opportunity to be heard.
I did want to share here, as you mentioned, the families. We did know the Gonsalves family did put out this statement here just a few days ago when they did learn the news that Bryan Kohberger accepted the plea deal. And they said, we're beyond furious at the state of Ohio. They have failed us. This was very unexpected. For the families here, I'm not sure if you can speak to this, but as this has unfolded over the course of years, months here, what was that process like for those families? Were they given a heads up here about this? Because it doesn't sound like they were.
From my understanding, they weren't given a heads up about this, so it probably came as a shock and surprise to them. I mean, this is years of their lives. Not only did they lose somebody that was near and dear to them, but they're invested in the outcome. And of course, some people take the position that if there's a loss of a life, we want to see a loss of a life on the other side. So when the death penalty is taken off the table, it really has probably impacted them significantly. And they're just processing through the other layer of grief that is compounded with the loss that they've experienced already.
I did just want to show our viewers live outside the courtroom right now, giving you this live look as we can see a lot of media there, waiting to see if we can get any statements as we do watch this live together. Joanna, I did also want to ask you, though, just about the future of this, because, again, we did hear from the family of Kaylee Gonsalves, and just a short time ago, they also did post this morning on their Facebook page, actually, asking people to write into the Department of Justice about this. And so moving forward, is there really anything the family can do here, or is this pretty much a done case?
So we're in a position where both sides have entered into an agreement. The judge does have the kind of discretion not to accept the plea deal. However, will we get to that point? I think what the plea deal is arranged is that this is going to be consecutive life sentences plus the 10 years on the burglary. I do feel that the judge will give the victims an opportunity to state their case, state their feelings, but I think he's going to approve the deal.
And Joanna, we did ask our viewers to write in some questions, and I would love to get to some of those right now. So I did want to pop up this on our screen here. Kendall Z is saying, will any evidence be hidden even after sentencing? That's a good question.
Yeah, absolutely. I think everybody has an interest in what's happening in these cases. It's highly scrutinized. There's a lot of media attention. Everything is not as accessible as, we'd always like it to be. Even as attorneys, sometimes we have difficulty getting our hands on evidence. So, in terms of whether or not things will be released to the public and be fully visible, I think that there will be things that are hidden or kind of kept under wraps. Also for the protection of families, we don't really want to release images and, sensationalize the murders that took place. And so will there be an actual sealing order? I don't think so, but I do think that, the public won't find it as easy to access.
We do have another question coming in here. Why was Kohberger offered a plea? And this was coming just about less than a month or a month away from when this trial was set to start here in August.
Yeah, absolutely. That is a great question. And it's probably what the families are wondering too. Why are we doing this after we've spent so many years dealing with the aftermath of the murders? But realistically, trials consume a lot of time, even if the prosecution has somebody dead to rights and they do think that they can make, prove their case and get their convictions. Sometimes it is more expedient to put the deal on the table and get a resolution where they have a conviction on all the counts. He's facing life without parole. He's going to spend the rest of his life in prison and effectively die. And they're just taking the death penalty off the table, entering into this plea agreement. So, I would imagine that in the prosecution's eyes, this was a means to an end that accelerated the outcome that they were anticipating.
And then another question here, does the judge have the right to not take the plea deal and still give him the death penalty? You've touched on this question here just a little bit, Joanna, but is there anything else that you would like to speak to that?
No, the judge does have the right to, decline accepting a plea deal, but he wouldn't be able to just kind of impose his own sentence. He might kick them back and say, hey, this is going to go to trial. But realistically, I don't think that's what the judge is going to do here.
Now, I want to go back to what we just watched live. We watched Bryan Kohberger pleading guilty in court there. As we watched that, was there anything new that we learned? Is there anything that stuck out to you? Or was this what we already knew?
I think this is what we already knew, that there were, when they're reciting the factual basis, where the car was, what the cell phone records pointed to, the Amazon purchases, the DNA evidence, all the things that the defense tried to keep out but got in anyway. This is probably where, the defense said, hey, we filed all our motions were denied, we're looking down the barrel and it's not looking good. And the prosecution was really confident in their case. I think this is what we expected would have played out at trial. And this is part of the reason that they reached this disposition.
I did want to ask you about if this did go to trial, because what we do know about this is authorities have said cell phone data and surveillance video showed Kohberger visited the victim's neighborhood at least a dozen times before the killings. We also do know his online shopping records showed that he had purchased a military-style knife just months earlier, as well as a sheath that was similar to the one that was found at the scene. When we talk about evidence, and again, this is now not going to go to trial here as he just pleaded guilty, but if it had, do you think that the evidence was pretty stacked against Kohberger? How difficult would this have been to prove his innocence?
It was definitely stacked against him. It was, primarily circumstantial. We do have the surviving roommate who identified, seeing him run out of the house. But, we're looking at all of the circumstantial evidence that's pointing to the fact that it's him. He's in the area. They see his car. He's, going back and forth. So I do think that a jury would have leaned in favor of the conviction, and the prosecution would have prevailed on their counts.
Just a couple more questions, Joanna. I did want to share this one because this comes back to these unanswered questions and that question you already answered about will evidence still be concealed. This other question, will he be required to share specific details? Because again, there's a lot that we have learned here leading up to all of this. I feel like these tidbits would come out of just a little bit more insight into what exactly went on that night, but there are still so many questions.
I think everybody would have loved that he would have to allocute and explain, himself, answer some questions, give the family some closure, give, the motive for why he did what he did. And, he's accepting the fact and saying, yes, I did this. I'm guilty. But why? And no, there is no requirement as part of this deal for him to give the specifics of that. We can anticipate that somebody who's spending the rest of their life in prison is, maybe trying to anticipate his future and maybe some media attention later on down the line, maybe publication rights to his story. That might be what he's holding on to, but as of right now, he doesn't have to share it.
I did want to pull up one more question that we are getting in here before we wrap up with you, Joanna, and this is, are there any civil charges that can be made against Kohberger outside of the restitution?
for the conduct. They are allowed to bring a civil suit. There are completely different venues, criminal court and civil court. And of course, he's already admitted guilt. So that would be a strong finding. The burden of proof in criminal court is higher than it is in civil court. So that would be dependent on whether or not the statute of limitations has already passed on the crimes that they're, or the allegations that they would be making in a civil suit. But overall, yes, there can be two separate actions.
All right, and lots to watch as this does continue to unfold here. Joanna, is there anything else that you'd like to add about this that you think we didn't touch on? I know we touched on a lot.
Yeah, we definitely touched on a lot. I think the public is invested in this, and understandably so. And I think right now it's just anticipating what might happen at sentencing and being prepared for what those arguments are going to be. But I think I think we've got a really good insight onto what the judge is going to do and where he's going to lean with this.
All right, Joanna Nieves, thank you so much for joining us on Live Now from Fox. We do appreciate your time.
Thank you.
All right, we're going to go away for a break. My name is Christy Matino. Thank you for being with us here on this busy breaking news day. Much more news to get to. Don't go anywhere.
One, two, check, 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 test, 1, 2, 3, 4, 5.
Good afternoon. I'm Leander James from the law firm of James, Vernon and Weeks in Coeur d'Alene, Idaho. I'm a victims' rights attorney. For the past 2 years, I've had the privilege and the honor to provide pro bono representation in this criminal case for Karen Laramie and Scott Laramie, the loving mother and stepfather of Maddie Mogan. I will be reading a statement of gratitude today from the Laramies. 962 days ago, we lost our Maddie, our kind, loving, vivacious, and caring daughter full of purpose and promise. We are grateful for the gift of her life, and we have grieved the loss of that life during each of these 962 days. We love you, Maddie, and we miss you. We are grateful for the gift of the young, vivacious, promising lives of Kaylee, Xana, and Ethan, and we deeply, deeply mourn their senseless loss. We remain in solidarity with their families and friends, and we continue to shower them with our prayers and support. We are grateful for their prayers, love, and support that they have given us. They have helped us and sustained us during our darkest times. We are grateful to the prosecutor, Bill Thompson, and his dedicated and caring team, including victim coordinators, Kim and Stacy, who have helped to guide us through the sometimes confusing and disorienting legal process. Thank you for all your dedicated, diligent, and tireless commitment to justice and the successful outcome reached today. We support the plea agreement 100%. While we know there are some who do not support it, we ask that they respect our belief that this is the best outcome possible for the victims, their families, and the hope. We extend our deep gratitude to the many law enforcement officers and staff who worked tirelessly to obtain the critical evidence that brought justice today, including the Moscow Police Department, the FBI, the Idaho State Patrol, and the Lehigh County Sheriff's Department. We are deeply grateful to Judge Hippler and Judge John Judge before him. We thank you for your diligence, thoughtfulness, and judicial guidance. We appreciate the difficult work you have done to balance the rights of all involved and to uphold the rule of law. You have had our prayers and support throughout this case. We send our love and gratitude to the many family and friends who have supported us, cared for us, and helped us to heal our open emotional wounds. To the good people of North Idaho, who have showered us with kindness and support, we thank you. We also mourn today with you the recent tragic and senseless loss of two brave North Idaho firefighters. We extend our prayers and support to their families. You are not alone. We understand your pain. For all parents who have endured the loss of a child, we know recovery is a long and at times an almost unbearable journey. But you are not alone. And there is hope and there is healing. We thank those in the press who have respected our privacy and the grieving process, and the privacy and grieving process of families of Kaylee, Xana, and Ethan. To others in the press, we gently encourage you to do the same. We thank the many people across our nation and beyond who have reached out to us, prayed for us, and extended their kindness. You too have helped us on our journey to heal. We now embark on a new path. We turn from tragedy and mourning. We turn from darkness and uncertainty of the legal process to the light of the future. We have closure. We embark on a path of hope and healing. We invite all of those who have mourned with us to join us, and we wish you well. Thank you. I will now share a few words of my own. Over the past 2 years, I've been amazed and humbled by Karen and Scott's strength, endurance, and faith. They have uplifted me and so many. They founded a nonprofit to help others in the name of Maddie. They have been a beacon of hope amidst a dark and tragic time. To those young and bright attorneys out there looking for purpose and meaning in your profession, I invite you to join the effort of crime victim attorneys to bring victims justice with compassion, empathy, humility, and understanding. This case is not the end of violence. This case is not the end of lawlessness. We need your help to bring hope and healing to the innocent caught in the crossfire of life. Thank you all. Leander James, Leander, last name is James. Thank you.
all this black is not good.
They're an hour into their drive to Priest Lake, I'm pretty sure.
They're an hour into the drive to Priest Lake. Well.
You the pool guy? With AP?
Thanks again, man, for letting me. All right, come on. There we go. I just tangled it up. Sorry.
We're good. We're good. Not worried.